everyone. My name is Ann Cleveland, and I'm a paralegal at Liles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Avoiding Criminal Liability, Views from a Federal Prosecutor. Today's presenters are Robert Liles and John Pierce. Robert Liles is the current managing partner at Liles Parker. In addition to a law degree, Mr. Liles holds both an MBA and an MS in healthcare administration. Robert has worked on the provider side as a federal prosecutor and now represents home health, hospice, and other healthcare providers around the country in connection with Medicare, Medicaid, private payer audits, and False Claims Act cases. While working as a federal prosecutor in Houston, Robert was asked to serve as the country's first national healthcare fraud coordinator for the Executive Office for U.S. attorneys in Washington, D.C. In this capacity, he advised federal prosecutors around the country regarding healthcare fraud statutes, schemes, investigative tools, privacy concerns, and compliance issues. John Pierce, a partner at Liles Parker and a graduate of UT Law School, is an experienced former federal prosecutor and trial attorney whose practice focuses on sophisticated criminal defense and civil litigation. Prior to entering private practice, Mr. Pierce served as an assistant U.S. attorney in the Southern District of California, the District of Columbia, and in the Eastern District of Virginia. While working as a federal prosecutor in the Eastern District of Virginia, he represented the office on the Attorney General's Advisory Committee, AGAC, for healthcare fraud. Since leaving the government, Mr. Pierce has successfully represented both foreign and domestic individuals and corporations in healthcare, commercial securities, corruption, export control, and tax disputes. He has also handled a number of whistleblower cases. He prosecuted antitrust claims worth $1 billion, and defended corporate clients in commercial litigation and conducted internal investigations. And now, without further ado, I present your speakers, Robert and John.
Thank you very much, Ann. I appreciate it. Here with my friend, John Pierce. John and I have known each other for, gosh, how long has it been, John? 20, 25 years now?
I think it's almost 30.
Yeah, that's
maybe
right.
25.
I'm really pleased to have you on this call with me today, John. When I first met John, John is a very unique individual and has a rich history as a former federal prosecutor. He was, in fact, a federal prosecutor out of the San Diego office, but he was also a federal prosecutor in the D.C. office and in the Eastern District of Virginia that is known as the Rocket Docket. The way I met John is I was on the Attorney General's Advisory Committee in Washington, D.C., and his U.S. attorney at the time in the Eastern District of Virginia, rather than attend this because she was the official member, she would have John go. So John would sit there with all these presidentially appointed U.S. attorneys and decide policy for the 94 U.S. attorneys' offices around the country. So that's how I met John, and I've had the good fortune of working with him for many years. And today we're going to talk about the views of a federal prosecutor when it comes to healthcare fraud. And we're going to focus really in on just Texas, okay? That's really kind of where the focus is going to be today. Let's go to the next slide. Now, even though we're actually talking about home health and hospice agencies, the fact is you need to remember the folks on this line, whether you're the administrator, the owner, one of the chief nurse, a medical director, whatever your position is, one thing to kind of keep in mind is that DOJ has really kind of done an about face when it comes to prosecutions. I mean, we all remember at the very end of Bush 2 and the beginning of the Obama administration when we had the banking collapse. And the government had to pump, I don't even know how much it was, billions of dollars into supporting the financial system. And it was all because of these acts of individuals that worked at the banks. But my point is, you can't tell me, the folks on this line, can't tell me a single person who was prosecuted for that malfeasance. Not a single one. One of the things that happened in subsequent administrations, and whether we're talking about Republican administrations or most of the time, of course, it's been Democratic administrations since Obama has been in, is DOJ has formally change the focus of its efforts. And this really is a reflection of the fact that if a corporation does something bad, remember, a corporation is just a fictitious person. It's not a real person. The only time a corporation violates the law is because someone at that corporation has engaged in wrongful conduct. And in recognition of this, DOJ has issued a number of policies over the years that really kind of recognize that DOJ's first and foremost focus or targets are going to be the individuals who actually caused the problem. Okay. Now, this is important for the folks on this line, because to the extent that your organization is investigated by the government, will the government go after the organization itself? Well, possibly. But you have to understand that there's actually internal guidance now at DOJ that before they go after a corporation, they have to explain why they're not going after the individuals that caused the problem first. So, you know, the point I'm trying to make here is that the folks that are listening to this call, you are the ones that are in the sights of the government. If there's a problem, they're going to be going to the individuals that they say really committed the misconduct. Then they will look possibly at, okay, do we want to kick out the business or not? Yes, John.
Right, I'm sorry. I just wanted to give a little bit of context to our listeners. Back when I was in the government, as Robert mentioned in the introduction, I mean, that's been 23 years ago, but I was in the government for 14 years before that. It was almost universal that if there was what we call a white collar issue, a corporate crime, accounting fraud, or some sort of fraud or wrongdoing within a company, so often the attorneys would manage to offer up the company for a plea and a big hefty fine and let all the officers off the hook. That was just sort of a standard approach to dealing with white collar crime in the past. And these policy changes are, as Robert indicated, they are to reflect that there's no such thing as an entity committing a crime. Only the people behind the entity making the decisions can possibly be responsible for the conduct. And that's why the shift in these policies over the years. It was really triggered, as Robert said, by the meltdown in the banking industry. But it had been brewing for a while, because for a long time, people in government thought this is silly that we should let a company plead guilty and all of the decision makers go free. So just a little bit of context behind why this policy evolved and why here today, you know, none of you can hide behind your entity, because the government is going to look to the decision makers to figure out who should be responsible. I'm sorry to interrupt, Robert.
No, not at all. Not at all. Okay, next slide. Now, I know that, in fact, you know, we're talking today about criminal liability, but as we get into this, you're going to see there's really no way to separate criminal liability from the Civil False Claims Act when it comes to the criminal anti-kickback statute. Okay, and so I just want to kind of point out that the False Claims Act, the Civil False Claims Act, is alive and well, and the government is collecting billions and billions of dollars under the Civil False Claims Act. And as we will discuss, one of the ways that they're doing this, especially when it comes to home health agencies and hospice agencies around the country, not just Texas, one of the ways they're doing this is they're bootstrapping off of the federal anti-kickback statute in order to bring the Civil False Claims Act cases. Next slide. Now, John, this is a slide that I'd really like to get your input on. I think it's interesting because, John, when you and I were prosecutors, that was the first time, if you remember, Attorney General Reno came out and said, healthcare fraud is the #1 white-collar priority of this administration. Well, they haven't said that since then, but if you look at the numbers, that's still the situation, isn't it?
Well, I think it also reflects the enormous amount or more or enormous percentage of the U.S. budget that's dedicated towards, for instance, Medicare. So the government feels like we're pouring so many resources into healthcare, and it's all based on trust. Every time that there's a claim submitted for payment by the government, by one of its programs, it's based on the trust of the information provided. And that's why they, in the 90s, as you mentioned, they added the FBI in the 1990s to healthcare fraud enforcement. And that's what sort of was part of Attorney General Reno's emphasis on pursuing fraud in healthcare. And ever since, you're right, that's been the majority of where claims are made and recoveries are gotten on behalf of the government.
And these numbers here, John, that we're looking at, this is only from the DOJ fraud section. Folks on the phone, that's the group up here at Main Justice who works with the U.S. Attorney's offices around the country on a number of, but not all, cases. So keep in mind, these are the cases that they've worked on out of D.C. That does not include all the healthcare fraud prosecutions from the 94 judicial districts around the country and the accompanying U.S. Attorney's offices. Next slide. And this slide, this is just to kind of focus on the state level. I mean, we just talked a minute ago about the federal level and how healthcare fraud really overshadows all the other enforcement areas that DOJ is prosecuting. And and that's really at the federal level. But if you go down to the state level, you'll see that the MFUCUs, the Medicaid Fraud Control Units. The first time I heard that, I thought somebody was disrespecting my mother. Mm-hmm. But the MFUCUs, and there's one in each state, plus the District of Columbia. They are very, very active when it comes to their own state prosecutions of Medicaid fraud, Medi-Cal fraud, TennCare fraud. So it's really something you have to kind of keep in mind, because many of the folks on this phone, the home health and hospice agencies that are on the phone right now, you participate in Texas Medicaid and in one or more of the Medicaid managed care payer programs. So, this is not just a federal thing to worry about. It's also very active on the state side. And John, just to it's a little off topic, but not really. You and I are both currently working on, we're talking today about home care or home health and hospice, but a number of the people on this call also work in the area of personal care, and you and I are both working on, you've got a couple criminal personal care cases right now, don't you?
Yeah, and they're being investigated and brought by the Medicaid fraud control units who report to the state attorney general's office. And something for these listeners to bear in mind is that, of course, the state Medicaid funds are underwritten by the federal government. So it's still federal government money that's at stake. And that's also what's funding these state agencies to enforce the laws. But they tend to be very aggressive in the eyes of the people that are the subject of their investigations. They'll send out, hordes of investigators simultaneously to different locations, pounding on doors and demanding immediate interviews. And I was thinking about this the other day, and I think sometimes the reason they seem so aggressive is that if it's the FBI, they can always just go get a search warrant and knock somebody's door down and go in and grab all the evidence and information and sit people down for immediate interviews. But these Medicaid fraud control units don't typically have those same resources. So they want to get the same information, and they'll send out teams to try and get it fast and furious. So if you have ever been in this situation or know of someone who's got an agency like yours, and they've been subject to one of these blitzkriegs of an investigation, I think that's why. But they are very aggressive, and that's why, you know, the underlying message today is going to be prepare in advance, have your compliance plan in place. But for goodness sakes, if you ever get contacted by somebody in Medicaid fraud control, you've got to reach out to your lawyer right away and have them interfacing instead of you with these investigators.
Yes. Okay, next slide.
Robert.
Yes, sir. And John mentioned, you know, taking steps to be proactive and have a good compliance plan in place. I mean, the fact is, there is a report that just came out late last year by the U.S. Sentencing Commission, and it was really fascinating. And they looked at the situations where the government did prosecute corporate defenders. And what was so interesting about it was that they were almost all U.S. companies, they were almost all private, and many of them had less than 50 employees. An overwhelming majority of them didn't have, like almost 90%, didn't have a compliance plan in place, okay? Now, this is not limited to just healthcare, but it's so interesting because of 5,000 prosecutors that were criminally prosecuted, only 11 of them got that break, the reduction in sentencing, because they had an effective compliance plan, okay? That is really interesting. And you know, as healthcare providers, under the Affordable Care Act, of course, for the home health and hospice agencies and the personal care people that may be listening, if you're getting Medicare or Medicaid monies, you're supposed to have an effective compliance plan in place. And for those of you who are participating in Medicaid in Texas, you know, also keep in mind that when you fill out that participation agreement, you're swearing that, in fact, you do have a compliance plan in place and that you're screening all of your agents, employees, and contractors, you know, on a regular basis. And, you know, to avoid penalties, of course, you have to do it every 30 days. John, do you have anything to say about compliance?
Yeah, it's if you have a compliance plan in place, the chances of ever running into certainly criminal issues are going to be remote. I can't tell you how many times, Robert and I can't tell you how many times we get a call from a new client and, you know, they've gotten a subpoena from Medicaid fraud control, which means it's already been elevated to a criminal investigation. And then we learn that, well, you know, a couple of years ago, they did an audit, but we didn't think anything of it. And we think to ourselves, oh, why didn't you call us when there was an audit? We could have identified the issues and kept it from ever becoming a criminal investigation. And then even before an audit setting, if, you know, 2 years before that, if you go to the trouble of implementing a compliance plan, then you're most likely never going to run into an audit because, you know, you'll know what's right and what's wrong, and you'll know who to ask if there are questions about what's right and what's wrong. And the payments never become subject to an audit, and then they never become subject to a criminal investigation. So that's the power of a compliance plan, is keeping yourself out of ever having to contact a criminal lawyer.
And I will say, there are many times we'll get a call from someone and they'll say, well, you know, we were audited, or we did get, you know, a request for information from the government, whether it was from the OIG on the federal side or the, you know, HHSC OIG at Texas, or the Mafuku at Texas. But that was almost 2 years ago, so we don't think it has anything to do with that. I'm sorry, folks. That's probably exactly what this is all about. The government takes a long time. It's a big ship to move. They are constantly, you know, working on these cases under the False Claims Act. You know, they have up to a 10-year statute of limitations under the anti-kickback statute. And most criminal statutes, they have a 5-year statute of limitations. So these cases don't just go away. It's very, very rare that they just go away. Okay, sometimes it's happened, but not very often. Now, one of the things that I did is I went back and looked at the public prosecutions that have taken place in Texas since January 1, 2023. So just the last 6 months. I know for a fact that there are, in fact, home health investigations and ongoing prosecutions in at least the Western District, the Northern District, and I'm sure there are probably some in the Eastern District. I'm not working on any of those. But from a public standpoint, in terms of activity, in terms of cases going to trial, indictments, and plea agreements, all the cases that were listed on the home health side were really out of the Southern District of Texas. Now that's a big district. We're talking, and it's places varying from Harlingen, McAllen, Corpus Christi, Houston, Laredo. That and throughout the Rio Grande Valley. That's really where a lot of these cases are from. Now, when I want to quickly kind of go through some of these, but you're going to notice one thing right off the bat, and that is that every one of these cases that is currently public since January 1, 2023, they all involve the federal anti-kickback statute. That is really the focus of what the prosecutors in Southern Texas are looking at. And if they catch wind of allegations of a violation of the anti-kickback statute, that's where they're going to focus. That's where they're going to go. So if we look at this first case, and this is really kind of, this is frankly reflective of many of the cases that we've seen over the years. In this particular case, the owner of the home health agency was paying marketers or recruiters, okay, and doctors, okay, to pull in referrals and to sign off, I guess, on these orders for home health services with Medicare patients. So that's one thing that you're going to see again and again is the use of marketers. And John, in a couple slides, John's going to go over this some more. But you have to be careful because, one thing to kind of keep in mind, business practices that are perfectly legal in other industries are illegal in healthcare, okay? Especially when it comes to marketing. That's a big deal, okay? All right, the second case that came up, paying cash kickbacks to Medicare patients to sign up. Wow. Okay, so we've already seen kickbacks to doctors, kickbacks to what they consider kickbacks to marketing people, to recruiters, and then now kickbacks to patients. Okay. In the next case here, this owner was sentenced to 5 years in jail, and she admitted that she paid people to certify the medical necessity for her patients. So they're paying kickbacks to doctors and others that to certify medical necessity. Okay. In the next one, we have everybody. This particular case, the two nurse owners, they were sentenced to 36 months and had to pay restitution of $1.2 million and 14 months restitution of $238,000. They were paying marketers, patients, and physicians for referrals. So they had just across the board. Now you kind of see where this is going. I mean, this is something that the government's very consistent with. In the next case, they were giving $500 kickbacks for initial home health certifications and $250 kickbacks for research. Okay. Now at trial, the defense tried to say that the defendant was only paid $50 an hour to go out and pass out flyers. Okay, and that's what the defense was, but the government was able to show that in fact his reimbursement wasn't based on an hourly basis, but in fact he was based on the number of referrals that were generated. Okay, so all of these cases are very similar. They involve kickbacks of various flavors. But that's really kind of, you need to know that in Texas right now, especially in the Southern District, that's the focus. John, what would you kind of talk about this, would you?
Yeah, I was a federal prosecutor for several years, and I've been dealing with federal prosecutors for many more years than that. And it doesn't matter if I'm talking to one in Harrisburg or Houston or Santa Ana or Jackson, Mississippi. They all have the same view. To a prosecutor, healthcare is organic and it's nothing else. There is no cause for any relationship of anyone in the healthcare system besides doctor and patient. So if a doctor identifies an issue and makes a referral for treatment, then it's organic. If there's anything else involved, then a prosecutor's like, well, that's an unnecessary expense. And if there's a home health agency and it's trying to, locate people in the community or in the outlying community, a call center that finds a calling list of people who may be eligible, may have relatives who are eligible, and they start making the calls and making the referrals, well, that's a red flag to a prosecutor that's somebody who's creating a service that's not necessarily medically necessary, because it's not the doctor identifying the issue and making a referral. So it doesn't matter if it's home health, it doesn't matter if it's lab work, anything that has to do with medical care. If there are additional layers involved in referring the service and providing the service besides doctor and patient and the other provider, then the government is going to be looking at it. So you have to be very careful, and we're going to talk about it. A lot of people try and wedge themselves into safe harbors, and they're not exactly sure. They don't quite understand it. They get themselves in trouble if they don't have guidance on it. So before I don't want to get ahead of us, Robert. So
Okay.
Go ahead with the slides, and then when that comes up, we'll talk more about it.
Okay. Well, if there is any good news in today's webinar, it would probably be the fact that we know that there are ongoing hospice investigations and audits going on in Texas, but there haven't been a lot of prosecutions since January. Okay. In fact, neither of the two cases I have listed are from this year. All of the cases that I listed in the previous slide for home health, they were all since January 1st. These two cases were just examples that I found. Things are very quiet right now when it comes to hospice agencies. Not a lot out there. The reason I wanted to bring up this particular case, though, in the Southern District of Texas, this is from I believe last year. But the reason I wanted to bring this one up, though, is because in addition to all the other programs or all the other issues we've been talking about, falsification, false certifications, illegal kickbacks, they also had what the government said were medical directorships that were really pretenses for just an excuse to make referrals to the hospice. And we're going to talk about medical directors in just a few minutes, but that's kind of one thing to keep in mind. Is I know that home health agencies and hospices, most of you, all of you probably have one or more medical directors. And that's one of the first areas, one of the first fruitful areas that the government's going to be looking at whenever they do an investigation of your agency, is they're going to want copies of all of those contracts. Okay. And we'll talk in just a few minutes about what exactly they're going to be looking for when they're examining those contracts. But before we do that, let's just kind of go through very briefly, next slide, very briefly just about, how did we get here? The anti-kickback statute, it's been around a long time, since 1972. Wow. It's been here a long time. And when it first came out, it was pretty straightforward, and it was just a misdemeanor. Okay, things have changed. They made changes to it in 1980. They introduced this idea of knowing and willful conduct. Next slide. And then it was, over the years, it's been elevated to the level of being a felony. Okay. Now, under the Affordable Care Act, they made some more changes. And John, I want you to kind of talk about this. They introduced this idea that you don't have to have actual knowledge and you don't have to have specific intent in order to violate this criminal statute. John, what would you say about that?
Well, most crimes prosecuted don't require knowledge of a particular statute or knowledge that conduct would violate a particular statute. What most laws require, and they just brought this in line with it, is that the person need only know that they're committing the conduct. So, in order to the level of intent, the mens rea component of a criminal charge, they have to demonstrate that the person knew what they were doing. They knew there was a particular statute involved, not that they knew what the language of a statute was, not that they knew that the statute said that what they were doing is wrong, but just that they had knowledge of what they were doing. So it used to be what we called a specific intent crime, where you had to know the language of the statute and know that you were violating it. And that's the exception to the rule. So the Affordable Care Act has brought the kickback statute and its conduct in line with most other offenses. Just to use a simple analogy, somebody doesn't have to know that there is a statute that outlaws bank robbery, and that it's unlawful to rob a bank. If they rob a bank and they knew what they were doing is going in and taking money of somebody else's, that's all they need to be able to show for intent. And so that's where we are now with the anti-kickback statute.
Great. Next slide. Now, some of the other changes that have occurred, it's not really recent anymore, but feels recent, as long as I've been dealing with the statute, John. The fine is now up to $100,000. You can get 10 years in jail, not 5 years anymore, and it's quite broad. I mean, the way the courts read it, there's a case out there called the Grieber case, and the Third Circuit created something called the one purpose test. And even if you can point to 5 other reasons why your conduct was not intended to violate the anti-kickback statute and was for a reasonable and noble purpose, if one purpose of what you were doing was to generate referrals, then it's a violation of the statute. Next slide. Now, the statute is so incredibly broad that you have to kind of keep in mind it's so broad that in fact both Congress and the OIG have identified exceptions to it. They don't really call them exceptions; they call them safe harbors. So there are 2 flavors of safe harbors, if you will. There are statutory safe harbors, and there are regulatory safe harbors. Well, the number of safe harbors has consistently grown and grown and grown, so that today there are actually 11 statutory safe harbors and 36 regulatory safe harbors. So essentially, there's 47 different fact situations that if you meet certain requirements, even though technically the conduct would constitute a violation of the criminal anti-kickback statute, if you meet these requirements under these 47 or one of these 47 safe harbors, it wouldn't be considered a criminal violation. Okay? Now, safe harbors, they're voluntary, they're not mandatory, and you don't necessarily have to meet all the requirements in order for the conduct to still be legal. But if you want the protection of the safe harbor, you have to meet every one of those requirements.
And I'll give an illustration of a safe harbor, that we see all the time is if there is, let's say, marketing that's employed by an entity in the medical field, and I don't know if it's used as much in home health. Robert, you probably would, but if someone is using marketing and they're paying for it by the hour, let's say, that may be or they have an employee paid by the hour to provide marketing. That may fall within a safe harbor. So what so often happens is that the arrangement is disguised as an hourly arrangement with a marketer, but they're really back-ending it and calculating payment based on, well, how many bodies are they actually referring to us? And that's where you can tell somebody's trying to fit within a safe harbor, but they're not. So another message to impart today is that something that Robert and I see all the time is that when somebody comes to us, they'll say, well, we know it's okay because our counterparty had their lawyer look at it and work it up and everything's okay. And anytime you hear that from a counterparty saying, my lawyer's already taken care of it, it's all on the up and up, don't believe them. It might be true, but you better have your own lawyer take a look and make sure, because what happens, I can't tell you how many times, Robert and I see it, where someone then digs up the contract that they say the other lawyer provided, and it's not a contract about that particular transaction at all. It turns out that it was taken from some, lawyerly writing written for some other issue, and the counterparty just tried to sort of work it into this particular situation, and it doesn't apply, and it's not a safe harbor. And instead of operating on the up and up as you might have thought from the get-go because another lawyer looked at it, all of a sudden you're in the soup because you're not in a safe harbor. So as Robert says, this statute and these safe harbors are very, very complicated. You really want to get an opinion from a lawyer before you launch into a situation that's going to somehow trigger an analysis under the anti-kickback statute.
Yeah, and John, I just want to add one thing to that. My grandfather was he was a judge, and he was in private practice down in Texas for many, many years. And in those days, the attorneys did everything. He would do a oil and gas case one day and a murder defense case the next. But I asked him one time, I said, Grandpa, what was your area of focus? And he said, whatever your problem is, that was my specialty. Now, the reason I bring this up is because it's, we see situations where somebody went out and they got a good corporate lawyer or a local lawyer who does all kinds of business type work, and they looked over the contract and the contract looked just fine. It was a good lease, or it was a good management contract. It was perfectly fine. But he wasn't a healthcare lawyer, didn't really understand what safe harbors were, and didn't understand the importance of making sure that the conduct, that the paper and the conduct fits within the safe harbor. Okay, so be very careful. Okay, it's not even enough to get a lawyer to look at it. You need to get a qualified health lawyer to look at these issues. Okay, very, very important. Next slide. Now, let me just back up. Go back 1 second. The three primary safe harbors that we see in home health agencies are personal services and management contracts, the employment safe harbor, and the small entity safe harbor. Now, let's kind of talk about those three real quick. Okay, next slide. All right, the personal services safe harbor. this really kind of covers a lot of different things. A lot of times, if you're going to have a medical director for your home health or hospice agency, this is going to be the safe harbor that relationship is going to have to fit within, okay? And, some of the things that we see that are always a problem is, it's got to be in writing. It's got to be signed by the parties. It's got to be for a year or longer, okay? And the methodology for determining compensation has to be set in advance, has to be an arm's length transaction, and perhaps most importantly, it can't take into account the value or volume of any referrals, okay? That's a big deal, okay? So one of the things that we see all the time is that they'll have a contract, and a lot of times they basically just documented the fraud because they put in there, for every referral that you generate for us, we're going to give you X amount of money. Now that's one problem we see. The other problem we see is they'll have a contract that says almost nothing. They're paying the medical director $2,000 a month. And then we ask them, okay, well, what is the medical director doing for $2,000 a month? And, the problem is, even if he is doing something that is worth his time for $2,000 a month at whatever the fair market value is an hour, they're not documenting it. So if there's ever an investigation and the government comes in, they're going to want to see, okay, well, you've been paying this doctor who actually sends referrals to your agency. You've been paying them $2,000 a month. Show us what the doctor has been doing for that money. And the problem is the doctor hadn't kept good records and neither have the agencies. Okay? So then the prosecutor jumps to the conclusion, rightly or wrongfully so, that the whole purpose of this arrangement, this for $2,000 a month, is really, a payoff for referrals. All right? So, keep in mind also your marketing people. If it's a 1099 person, an outside individual that's a marketer, this would be the safe harbor that they have to meet. Okay, you can't pay them, and I understand it's almost anti-American. Here in America, we want to compensate people based on their efforts. That's just what we do, right? But you can't do that in healthcare because if you give somebody, a marketer, $200 for every Medicare referral that they can generate, that does not meet the safe harbor, the personal services safe harbor. And that's going to constitute possibly a violation, a criminal violation of the statute. John, do you want to add anything to this one?
No, I think you covered it just right.
Okay, next one then. The next one, we see this all the time too. This is the employee safe harbor. And we have people who will say, oh, well, he was an employee. We were taking out taxes. We were paying him with a W-2. Well, that's one of, a dozen or more factors that the government is going to take into account. For someone to be a bona fide employee, and that's really kind of the key there, okay? It's not just enough that you take out taxes. You have to control the manner and means by which they do their work, where they're doing the work, how much work are they doing. You've got to show that you're providing the proper training. There are all these factors in here that the Supreme Court the Fifth Circuit, citing the Supreme Court, has come out and said that this is what we expect to see for an employee. So, it's perfectly fine, by the way. Just because someone is a bona fide employee does not mean they have to be full-time. You can have an intermittent employee, okay, who works part-time, and they can still be a bona fide employee. But and you can actually compensate them based on their efforts. But the problem is, they have to be a bona fide employee, okay? You've got to make sure that this person, and this is something that the government's going to look at. And then they're going to say, is this really an employee, or is it really just an outside contractor that you're taking taxes out of, okay? Next slide. And then the small entity investment safe harbor. there are certain requirements here. I mean, this is something that if you're going to try to fit within this kind of safe harbor, and like have a physician that wants to invest in your agency, got to be very careful. There are stark considerations to kind of take into account when you're talking about home health. Okay. And there are all kinds of kickback questions that come into play. For this particular safe harbor, you need somebody like Jennifer Papapanagotu, my partner down in Houston, or Heidi Kocher, my partner there in Dallas, to do this analysis and see. When you've got someone wants to invest in your agency, make sure that in fact it's not going to be a problem. Okay, because if that's someone that has the ability to send referrals to you, and we're not just talking about doctors. There's a lot of folks that can influence the sending of referrals. You need to make sure that particular business arrangement is going to be okay. One of the things that we had kind of talked about earlier today is medical director agreements. And this is something that's been out for quite a while now, but it's still very active. And I want to just refresh your memories about it. In 2015, OIG issued a fraud alert about physician compensation arrangements. Okay. And they talk about medical director agreements. All right. And they also talk about how, if you're going to have a doctor come in and that doctor is going to be a medical director, and you're going to pay them, well, just be careful, because whatever they're doing, it has to be reflective of fair market value. In other words, you can't be giving them $1,000 an hour, because if you're down in South Texas, what is fair market value for a physician's time? Well, I'm a lawyer. I'm not a CPA. I can't tell you what that is, but I can tell you that most of the time it's probably around $250 an hour, maybe $3, maybe less, depending on where you are. But the government's going to look at those business arrangements very carefully. John, what would you add?
You're covering it. Nothing to add.
Okay. All right. So these are some of the things that John and I have seen when it comes to home care and hospice agencies, including those in Texas. Since we were just talking about medical directors, I want to kind of throw another issue out there. Some of you have multiple medical directors. Okay, it's not illegal, but I will tell you it's a red flag, because the government looks at that and they say, it's funny how they've got 3 people who are serving as medical directors and they're all getting X amount a month, and they all refer patients to this agency. Okay, I can tell you the government doesn't like it. Now, in a perfect world, you would say, Robert, we have one medical director and we don't accept any referrals from that individual. But that's, that may be from a compliance standpoint, that's really wonderful, but that's not really something that we see very often, and it's probably not real life. John, which of these would you like to talk about that you run across?
Well, I think that the bottom line is that anytime you've got multiple medical directors, which is usually a job that's conducted by one person, certainly depending on the size of the organization, the government is going to just assume, well, that looks like a pay-for-play arrangement to me. So, just have your healthcare lawyer take a look at whatever your arrangement is with your medical directors, so that the government's not going to think that it was just a disguised referral compensation agreement.
Right. And one of the things that comes up a lot, not this time of year, but it'll be here in Christmas, giving gifts or things of value to patients and to doctors' offices that send you business. I mean, technically, a fruit basket I've never seen a prosecutor go after a fruit basket. Let me put it that way. But I will tell you that the anti-kickback statute, if we go back and look at it from a few slides ago, there is no de minimis. There's nothing there that says it's only a kickback if it's worth more than $100. Nothing there at all. So all of these things, these little things, do constitute a potential kickback. All right. Now, what have we seen recently? Well, not in the home health world, but I recently saw a case where the government actually went after a company who was giving tickets to sporting events and things like that, and they considered that to be prosecutable violations of the anti-kickback statute. And I'll also like to point one thing out that the government always hates, and there is never an excuse to give it. Okay, liquor. All right, liquor is something you would think that everybody is. Well, I'm not going to get into religion, I suppose, but there are some religions that don't drink. Okay, you would think everybody in the government's one of those. I'm telling you, the government does not like it when you give liquor to a referral source. Period. Okay, so be very careful. You don't want to go over the top. I know that you'll tell me, but Robert, this is what our competitors do, and we have to keep up with them. No, you don't. They're going to get in trouble. The one thing I'll say is, all of the cases that we see, and my clients tell me, but my competitors are doing A, B, and C. Eventually, they always get caught. Okay? They always get caught. They'll either have a key tam by a disgruntled employee, or someone will report them to the OIG on the hotline. By the way, the OIG hotline gets 60,000 calls every 6 months, I believe. You know, so it's just unbelievable. It's a very, very active hotline. So just be careful. Whenever you're giving, like we talked about before, it may be perfectly appropriate in other businesses. It's not appropriate in healthcare. And that means, you know, that's like lunches too. And I know you're taking, look, I've been there. I know you're taking boxes of donuts and all kinds of goodies to these doctors' offices and dropping them off, right? And it doesn't cost much. And you're thinking, how could that be a problem? This is just our marketing efforts. We always drop them off with brochures about our agency. The government doesn't like that. They absolutely don't like that. Okay, so keep that in mind. Now, you know, there are some exceptions to the food ban, if you will. If it's accompanied by bona fide education, a lot of times the government will not have a problem with that, but they don't like just pure marketing, dropping off food. Next slide. Okay, now the reason why we had that False Claims Act slide early on is because when they passed the Affordable Care Act, one of the things that they said is that violations of the criminal anti-kickback statute can be pursued as a violation of the Civil False Claims Act. So let me put it this way. If you're really lucky and the government's investigating you for an anti-kickback violation, a criminal anti-kickback violation, it's a good day, believe it or not, if they decide to only pursue it as a Civil False Claims Act. As crazy as that sounds. John, what would you say about that?
Well, any conduct that is a false claim can be prosecuted by the government either civilly or criminally. So if what you want your lawyer to do is to negotiate with the government into a civil resolution rather than a criminal resolution, but you don't always have control over that.
That's right. Okay, and then next, John, these are some of the statutes, John, but I know that next slide. I know that you've dealt with. Can you kind of talk about these two statutes?
Yeah, we're short on time, so I'm going to do it real quick. But the healthcare fraud statute has been codified as 1347 in the last few decades. Again, that's when Attorney General Reno gave authority to the FBI to investigate healthcare fraud. And obstruction of an audit is an example of, well, the obstruction can be worse than the underlying crime. Think, oh gosh, what's her name? She just escaped me. The famous homemaker, the famous cook.
Martha Stewart?
I think everybody out there. Yes, Martha Stewart. Remember, she was investigated for insider trading, and she got a pass on that, but she lied to the federal to the FBI agents who went out and talked to her about it, so she got prosecuted for that. So the cover-up is always worse than the crime. You always be wary of that. Are we going to the next slide?
Next slide.
21. And this is, I'll just say real briefly that the government was trying to tie identity theft with any healthcare offense with the theory that, well, if you're submitting a claim for payment on healthcare, you have to include personal identifying information of the patients, and therefore you're essentially stealing their identity. The Supreme Court has peeled back on that, but it's a bit of a Trojan horse. I mean, if the government's coming after you for healthcare fraud, the fact that they don't have this to add on to it, you shouldn't see as much comfort. We have false claims. I'm going to the next slide. False statements, and then another one is false statements under 1001. All of those are providing false information to the government. Remember, we opened this session saying that the whole system is based on trust. The government in the healthcare industry allows people to submit a claim for payment saying, I provided this service. And so they have to trust that whatever is being submitted for payment is true. So there's a bunch of these statutes that also make it a separate crime to submit false information. And that would take us to the next slide, Robert, 23.
Yes. Yeah. And we don't want you to think that you can only get in trouble for kickbacks. There's a lot of ways to get in trouble for non-kickback reasons as well. Okay. Failure to properly document medical necessity, that's something that can get you in trouble. And I will say that for those of you who occupy a position that requires you to be licensed, whether you're a medical director and you're licensed by the state board, or you're a nurse practitioner or a registered nurse, when you are responsible for filling out medical records and for filling out progress notes and the rest of it, and you don't do it properly, that very well may violate your obligations under the Practice Act, the State Practice Act. So be very careful. Another problem that we've seen just in administrative audits, haven't seen it on a criminal case yet, but in administrative audits, we've seen situations where people would fail to sign out on their treatment notes. And we would ask them, why didn't you sign out on the treatment notes? And surprisingly, more than one have come back and said, well, once you sign out, then you can't go back and make changes. Well, that's not a reason not to sign out and close the note. If you're audited and the notes are not closed, I can tell you that in Texas, the MAC and the UPIC are going to deny those claims, period. Okay? If you close them out and you see that something was incorrect, there are ways to issue a properly dated and signed addendum into the record, and that's what you need to be doing. Okay? Missing treatment plans, and this is really hot on the hospice side, consent forms. That's something that the government is really hot on these days because they want these hospice patients to know what they're giving up when they sign up for hospice care. And of course, they're giving up curative care. Okay, and that's something that the government's looking into, because if there's not a proper consent form on file and you haven't notified them of their rights and notified them of your obligations and the rest of it, you can get in all kinds of trouble. Allowing unlicensed staff to perform care, make sure that whoever you're employing, if they are in a licensed position, make sure that they are not working outside of their scope of practice. Very, very important that you do that. And make sure that if they're in a non-licensed position, make sure that they're not performing services that require that of a licensed professional. Next slide. Billing for services not rendered. Gosh, that's still very common. Lots and lots of cases out there. In that first sheet where we mentioned the fact that there were kickback. About half of those also included allegations that the agency or the certifying physician had billed for services that were not provided. Okay, so that's something that comes up all the time. Misrepresentation of a non-covered service doesn't happen a whole lot on the home health and hospice side, but it does happen a lot in other areas. I just put it up there because I wanted you to kind of keep it in mind. We see it a lot in Texas with the Texas Medicaid dental program, where they want to provide certain services, but they know that the dental plan is not going to cover it, so they call it something else. And then there's an audit, and we find out that they lied. Well, now they've turned this into a much bigger problem for everyone. Okay. And then finally, misrepresentation of the provider of the medical service. This is a big issue for everyone. You cannot have a physician providing services and then bill it under the number of another physician. Now, I recognize under Medicare, under certain circumstances, it may qualify for Incident 2, or you may have some locum tenens argument or something along those lines. But whether it's a nurse practitioner or a physician, or just make sure that you're not putting false information on that billing form. Very, very important. Okay. Final considerations, because we are just about out of time. I think that John really kind of summarized it best when we talked about that one sheet where we had those bullets talking about the different ways that kickbacks can come up. And John pointed out that it really comes down to analyzing your business relationships. You want to talk about that a little bit more, John?
Well, just again to highlight that what we want people and these listeners to pay particular attention to is that anytime you're entering into any arrangement, any business arrangement in the healthcare industry, and in this setting with home health and hospice, it may seem like something very simple, but it's great to just have a healthcare lawyer take a look at it and give you the sign off that, yes, okay, it does comply with all of these various areas, because we just see it all the time where we see a contract and, the client says, this is what covers me. This is why everything's okay. And then we take a look at it and go, you know what? That doesn't apply. Or those terms aren't what you were doing. So please think in advance, think compliance in advance, think getting your healthcare attorney involved in advance to give you the blessing so that you can cruise comfortably and smoothly without any sleepless nights, that everything is in order.
Yeah. All right, next slide. If you have problems, call your attorney first thing. Be careful. Don't don't turn a minor investigation into a major investigation by deciding that now it's time to do spring cleaning. Let's shred all this stuff. Don't do that. That's a bad idea. One thing and that's, these points are really kind of self-explanatory, but the one thing that I'd like to say is when I was a prosecutor, and I think that John feels the same way, we didn't expect people to be perfect, but we did expect them to try. And the government, they've been, OIG first came out with suggested compliance plans for home health. The first suggested plan that they came out with was in 1998, and they came out with one for home health, I think, in 99 or 2000. One of the very first ones was for home health. It's taken them 20 years, but DOJ has now kind of gotten on the compliance program bandwagon. And DOJ now, if it is a criminal case, if you hope to get some kind of credit for your efforts to do the right thing and to show the government, kind of like if assuming that they're like John and I were, we don't expect you to be perfect, but we expect you to try. you're going to want to get credit for your efforts to do the right thing. Having an effective compliance plan in place is paramount to doing that. Okay, it can't just be something that it looks great and it's 200 pages and you put it up in the closet with the old yellow pages. I'm kind of showing my age here because the people I have here in the conference room with me don't even know what yellow pages are. Okay, but you know what I'm talking about, folks. It has to be something that's living and breathing and real. Okay, so do what's best for you and your family and your agency and your employees. Put an effective compliance plan in place. Do periodic audits of your services. Make sure that the documentation is proper and you're billing it properly. Look at your business relationships. That's the first thing the government's going to do in every home health and hospice case. The very first thing they're going to do is they're going to say, where do they get business from? Where do they send business to? That's what they're going to say. And that drives a lot of what's going to happen in the future when it comes to any type of government investigation of your agency. John, final words, what would you say?
The only thing I would point out is that this slide of final considerations, this highlights you have an issue. So you can't, this isn't time to, this isn't okay, I'll just put in a compliance plan and everything will be okay. This is when you have an issue. This is a checklist of things that you want to keep in mind. On the handling employees, this is when you've already got a problem. You don't want to antagonize your employees. But frankly, folks, usually when there's a problem, it's because somebody's already been a whistleblower of some kind to the government to say, hey, these guys are doing this. And it's usually, frankly, it's usually an employee or a former employee. So don't just worry about handling employees when there's a problem. Make sure there's good communication and that you have a complaint line that you can address employees' problems openly and keep your employees assured. If they have a problem and they're not articulating it to you, they might articulate it elsewhere, and you don't want that. So part of handling employees is always have a good management structure, open communications, treat everyone with respect, and don't ever think that an employee that is griping about something is just a whiner. They might actually have legitimate beef that you want to know about before the government is asking you about it.
Great points, John. It's just the last thing that I'd like to say. If you get a CID, which is a civil investigative demand, and even though it says civil, a lot of times they'll be asking in there about business relationships and possible conduct or kickback activity. If you get a civil investigative demand, if you get an OIG subpoena, if you get a DOJ authorized investigative demand, which of course is only issued in conjunction with a bona fide criminal investigation, okay? Or if you get a search warrant, give us a call, okay? Give us a call. And we'll be happy to answer any questions that you've got. You can call John, you can call me. Next slide, we've got you've got our emails there and our phone number. We'll be happy to talk to you about these issues. Hopefully you'll never get anything like that, but if you do, we're happy to talk to you. One of the other kind of telltale signs is if you hear, and this happens all the time, you hear that agents showed up at a patient's house. A lot of times the patients will call you and say, hey, I had an agent just here at the house. Well, that's where John comes in, frankly, because the best thing to do is to try to nip this in the bud before they get too deep. And we find out, they left a business card with the patient or they left a business card with a former employee. John will get on the phone with the agent and say, hey, what's going on? We don't want to learn about something a year from now. If you've got a problem with what my client's doing, we want to fix it today. And a lot of times, it's very possible that can kind of deal with the problem early before it gets out of control. John, would you add anything to that?
Yeah, look, government agents have a lot of work to do, and if you can help solve their problem early on and they don't have to dig into an investigation, then they can focus on the next one. So let us do the early work for you. Don't let it fester.
There you go. There you go. Well, thank you very much. One of the attendees asked if we're going to have copies of this going out, and we are. I think that I'm going to make one correction to one of the slides, and we'll be sending that to Grace at TAHCH shortly.
And they'll all get them. You guys will receive copies of the presentation via email.
Oh, good. So everyone will get their own direct copy as well. Excellent, excellent. Okay. All right. Well, thank you very much, and we look forward to talking to you in the future if you have any questions. Have a wonderful day.
Thanks, everybody.